Today's story is about President Nicolas Maduro and the legal labyrinth that has pulled him into a U.S. court, a plot that began with a Trump administration claim of an extradition. In August 2023, U.S. Special Forces captured Maduro and his wife, Cilia Flores, in a raid in Bolivia. The first Trump-era government said the operation wasn't a military invasion but a legally grounded extradition that would eventually lead to a criminal trial. Many legal scholars, commentators and officials at the time celebrated that description as lawful, despite Venezuela's early backlash. Venezuelan officials said the capture violated international law and that the U.S. had no right to hold Maduro at all. Fast forward to July 22, prosecutors in the upcoming federal case could hit a wall. The United States federal courts simply do not have the authority to conduct the trial, according to a treaty that dates back more than a century. That treaty, signed in 1922, was part of a broader U.S. tradition of promoting international arbitration. President William Howard Taft, in his 1909 inaugural address, was a fierce advocate for the Hague Tribunal and arbitration treaties as tools for preventing war. After leaving office, he served as an arbitrator. President Woodrow Wilson and his secretary, William Jennings Bryan, also pushed for permanent independent commissions to settle disputes between nations. Their efforts turned the U.S. into a champion of arbitration when the world was on the brink of widespread conflict. Now, half a century on, a 1922 extradition treaty between the United States and Venezuela remains a living law. One provision states that any disagreements concerning the treaty's interpretation or execution must be decided by arbitration. That clause does not merely exist for paperwork, it binds the U.S. legal system. If the treaty is invoked, the case would have to be sent to arbitration rather than the U.S. federal courts. The crux: the Venezuelan government continues to insist that Maduro's seizure was illegal under international law, a stance that could trigger the arbitration requirement. Federal Judge Alvin Hellerstein, who has been overseeing Judge Heller's Supreme Panel, has said he must suspend proceedings and send them for arbitration if the treaty applies. The prospect is that, should the treaty demand it, the U.S. could be forced to release Maduro back to Venezuelan custody. What does this mean for the court and for national security officials? It underscores that a single treaty can hold up a high-profile case, no matter how grand the political stakes. Even if the U.S. approves the arrest quietly, when the legal process hits a treaty door, the courts may have to step aside. In short, the Maduro case is turning into the most visible reminder that U.S. international obligations aren't abstract. They carry real force, and they will continue to shape the outcome of cases that test the boundaries of weaponized law enforcement. That's why prosecutors are regarded as in for a big surprise when the case finally goes to court. That's all for today's briefing. Stay tuned for more updates as the legal drama continues to unfold. Thanks for listening. Until next time, keep questioning, keep listening.